Alright, so this is a suggestion via Discord. The name of the video is Fani Willis, Disqualification Saga, a new complaint against Fani Willis. Alright, let's check it out. Firstly, I have no idea who this person is, but we are about to find out, I'm guessing.
Many vowed to file complaints against Fulton County District Attorney Fani Willis for her prosecution of former President Donald Trump.
Now we are following the latest in the
Okay, so like retribution.
Fulton County District Attorney disqualification saga.
Okay, we've been wanting to talk to you about your ethics complaint against Fulton County DA Fani Willis. She's overseeing the Georgia 2020 case against Trump. Can you tell us about your complaint?
Yes, I just filed this complaint against Fani Willis because according to the Georgia Finance Disclosure Act, Fani Willis, as a district attorney for Fulton County, is required to file financial disclosures. All office holders, we all have to do this. However, she did not file financial disclosures in 2019, 2021, and 2022. Now we all know about her secret boyfriend. It is now public. She was having a personal relationship with Nathan Wade. Nathan Wade is the prosecutor that she hired and is paying the most money out of her entire team. And he has the least amount of experience. He's never tried a RICO case before. She's paying him $250 an hour, which is nearly $700,000 she's paid Nathan Wade, but yet they're having a personal relationship. Here's the problem. Nathan.
That definitely sounds like a conflict of interest, guys. I'm not sure that he should have been hired at all if they're having like romantic situations going on here, guys.
Wade did not file as a
But who is this person that's speaking here?
lobbyist when he courted Fani Willis as his girlfriend to hire him for this job. Now they've taken, luxurious vacations, Caribbean cruises, Napa Valley trips, and we don't know how many restaurants they've eaten at. How much has Nathan Wade basically paid off Fani Willis for the job that he is being hired to do, and he's being paid by the taxpayers here in Georgia. Fani Willis.
Okay, but all the things that you just said, are these things that are coming out of the taxpayers' pockets, or
has completely betrayed the trust of the people here in Georgia. She needs to be taken off of this case. This whole case needs to be dismissed. But the big thing that needs to happen is there needs to be a serious investigation on the ethics committee here in Georgia into Fani Willis and Nathan Wade. Both of them have serious problems.
It appears that Ms. Fani Willis is at the moment getting hit from every angle. You have the Georgia State Senate completely independently launch their investigation into this matter, the one that we just read about. Then you also have the chairman of the Fulton County Audit Committee launching a separate investigation into the supposed misuse of county funds. Then you also have the House Judiciary Committee at the federal level launching their own official investigation into Mr. Nathan Wade and whether or not federal money flowed through Fulton County to him. Then you have the presiding judge.
And guys, that's extremely valid. If that actually is going on, then yeah, there's definitely an issue here, conflict of interest at the very least.
In the actual RICO case against President Trump and his 18 other co-defendants, he's also demanding answers from Ms. Fani Willis, giving her a deadline of this upcoming Friday to answer questions in writing regarding this whole supposed affair. Then you also have the divorce proceedings between Mr. Nathan Wade and his actual wife, Ms. Jocelyn Wade, in which details about this alleged affair are beginning to come to light one after the other.
So Judge McAfee recently said you and the other co-defendants in this case can now appeal his decision to deny your motion to disqualify Fani Willis. Will you? What will you ask for?
Yes, that's what we're actually doing now. So we're preparing our appeal. He gave us permission, but in Georgia, we have to get also the permission of the Court of Appeals. So that's the next step. So we've got 10 days to ask the Court of Appeals to grant that same permission. If they do, then the case will go to the Court of Appeals. If they don't, we will ask the Supreme Court also to grant it.
I want to come back to that sequence, but first, you said in your statement after Judge McAfee's ruling that denied this motion, Fani Willis is not disqualified, that you nevertheless feel vindicated by Judge McAfee's order. Why?
There was a lot of tension filing this motion. It was difficult, and I was called a lot of different things, a liar, different motivations in filing it, everything other than just doing my job. And I knew I was just doing my job, so I was very happy that Judge McAfee saw the things that I saw the indecent ways that certain folks responded, and just the obstruction. Everyone was trying to obstruct us from getting evidence. They filed a ton of motions to quash subpoenas, called me a liar repeatedly, tried to not even get this motion heard. So I felt very vindicated with his statements that this was something more than just lies or had any improper motives, anything like that.
So, Ashley, I have to ask you, you described the process here. You've got the Judge McAfee's permission to take appeal at this point. You've got, you're going to go to the appeals court, perhaps the Supreme Court. What do you say to people who say this is an attempt by Donald Trump and the other defendants, Michael Roman, your client, just to delay until after the election to get this out of the campaign?
That's what sounds logical, though. I mean, why would you want this going on while you're running for president? Logic would state that. Emotion will state most likely whatever she's about to say.
And I've heard that a lot. I've heard that as a criticism, but the best way to avoid delay would be for Ms. Willis to step aside. She could have stepped aside originally. She could still step aside. If she chose to do that, there would be no delay because we wouldn't be able to appeal. So she could choose to step aside and this case could move forward. But, just because something might delay a case doesn't mean that I can avoid taking a legal path that I think helps my client and I think is the fair result. We just want a due process trial here. We just want a fair trial. And this is the only way that we can preserve his right to a fair trial is by continuing to fight this disqualification issue.
And this motion that you filed, triggered this national spectacle of the district attorney of Fulton County on the witness stand herself. You're questioning her about what you believe are grounds for her disqualification. She's pushing back pretty hard. At one point, she accused you of being confused about the facts. I want to take you back to that moment from right now.
Let's go.
You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020.
So that was the retort, and Willis also said you were lying several times during the trial. So how do you respond to that really you're just throwing sand in the gears of a prosecution of someone of people, including your client, accused of very, very serious crimes against Georgia state law and against the American democracy?
It's actually a really easy answer because 99% of what we alleged was not in dispute. So all of the facts that I alleged back in January, they did not dispute, probably 99% of them. The only facts that ever were in dispute were really when the relationship started. So, by filing this motion, there were a lot of things that were not known, but later were actually agreed to by the state. And so, all these things that said, oh, you're a liar, 99% of them were proven. And the other 1% that are in dispute are things like when the relationship started. And we believe that we proved that the district attorney was not telling the truth and that the special prosecutor was not telling the truth when they said that it started after she hired him. But that's really the only thing that's in dispute at this point. So, the statements that I'm lying and all of that that really, I think that was proven to be wrong. As far as her allegations that my client should be on trial, not her. We certainly weren't trying to put the district attorney on trial. We were trying to bring forward and bring to light the efforts that we thought should disqualify her.
All right, so basically what I'm hearing from this here is, all right, so the other side apparently is trying to look for something that can at least, as she's saying, basically disqualify her from being in the position that she's in. It sounds like retribution and revenge. It feels kind of petty, bro. Like, listen, we have so much going on right now in this country. Is this one of the things that we need to dedicate like every single one of our brain cells to, bro? I think we should worry about immigration right now, to be honest. This whole migrant crisis is absolutely wild. That's where we should be. This person here, I don't really care about her, bro. Right? If she has some type of conflict of interest, she obviously should not be a part of anything. If she is basically taking some type of money or to basically give to, her boyfriend that she hired, who she's paying $250 an hour, $700,000 a year, guys, that's absolutely wild. I'll give you that right now. I'll absolutely tell you this right now. That's crazy. That's a different case to look into, bro. All right. Absolutely.
And have you done all this in the interests of your client, Michael Roman, or his co-defendant, Donald Trump, who's running for president?
100% for my client. And I did this and I filed this motion on my own.
Okay.
I, did all the investigation, only talked to my client about it. My client knew about the motion. Obviously, he approved it before I filed it. But this was not some type of a colluded effort between other co-defendants or anything like that. And you can see that. That's evident because if you look at the hearings that happened within the week after I filed my motion, Donald Trump's lawyer wasn't even sure if they were going to join it at that point. So it's clear that they hadn't even made that decision yet, whether or not they were going to join it. They wanted to do their own investigation. So I think it's very obvious that we were on an island at the beginning and we were the only ones pursuing this. And then other people, once they saw all the merits to our argument and saw all of the investigative efforts and knew what really happened, then they joined on, and they were wonderful to do that, but they didn't do that at the beginning. And so I think that answers your question as far as if we were filing it for someone else's benefit.
I have been watching, as the nation did as well, that entirety of the trial. You had this motion to disqualify the Fulton County DA. As you know, it failed. The judge said, think you did not meet your burden of trying to prove that she had a conflict of interest that would hurt a right to a fair trial. Now,
I mean, listen, it is in fact a conflict of interest. This is kind of like on the outside of all of this looking in. It's definitely a conflict of interest. Does it have anything to do with whatever she's doing? Probably not. No. You're digging into her personal life. Should she be in the position that she's in? I think that's probably where you should have gone, right? Specifically, if she has the ability to hire her boyfriend, right, and pay him this amount of money, that's an issue, right? Go after her job in a sense, but disqualifying her doesn't really make much sense. Like, and I understand fully that the judge didn't even allow this because logically it doesn't make any sense.
now you are appealing that decision, but tell me, on what grounds are you going to appeal?
We're appealing it on a couple different grounds. We definitely thought that there was evidence of forensic misconduct. So we thought that the judge got that wrong, and that there was evidence that, based on a couple things that she did, one of them was this, what we call the church speech. After I filed the motion and before it actually was responded to, she went at Martin Luther King Jr. Day, she went in front of the church and actually gave this speech, this almost like sermon, where she was talking about my motives, talking about my client's motives, talking about the different factors of the case, that she had hired 3 different people and that we were only calling out one, and that it must be racist. And so that was one count. There was also a book that she gave some unprecedented.
All right, so you're saying about she went in front of people, started preaching. Here's the thing: here is all of what she said public information. If it is, that doesn't matter.
That it must be racist. And so that was one count. There was also a book that she gave some unprecedented access to the authors into the decision-making room where she made decisions on this indictment. So we thought that was forensic misconduct. But
okay, start with that. Lead with this. All right, this right here.
That plus the relationship and plus the way that everyone testified, the manner that they testified, we think all of that was enough to show that she should be removed from this case.
The book is the issue.
Yet actually the judge did not agree with you on a number of those aspects. I mean, the church speech in particular, he did address that notion, did believe that it may have had an impact on a jury pool, but of course it was a prospective one that was in the distant future. But on the issues particularly of the misconduct and the witnesses themselves, you had witnesses who took the stand. There were a couple that really stood out to me. One was the former employee of the DA's office. There weren't many follow-up questions to corroborate when she had seen them kiss or hug in that respect. Also, you had the former law partner and friend and lawyer of Nathan Wade, Terrence Bradley, I believe. And it seemed as though he was refusing to admit much of the conversations you claimed to have had with him. Even he was evasive. He did not want to answer questions citing privilege. Do you think he led you astray, and did you misjudge the quality of his testimony?
No, and you know why? I know Terrence. I've known him for many years. I think he was truthful in his conversations with me. And if you look at how things happen, you look at the timeline, he was talking to me. He was very truthful. He had a lot of context. And that's one of the things that we look for when we're evaluating credibility. Do you have context to what you're telling? And he would tell me things and then give me context, give me details that only someone who actually had firsthand knowledge would know. And I was also able to corroborate a lot of things. So he gave me details such as Robin Yurdy. He led me to Robin Yurdy, and I was able to actually corroborate Robin Yurdy, corroborate the condo, he had led me to that. So those were things that told me that he was telling me the truth. But when he was
may
on the
have
stand,
oh, excuse me, I was going to go to that very point. I'm sure you're going the same way. He may have led you to believe that prior to actually taking the stand, but the first time we saw him, he was saying that he couldn't say anything without the bar of Georgia essentially giving him an opinion that he could, had an in-camera conversation with the judge about this very issue. And really, I mean, it was no easy feat trying to get him to answer a single one of your questions, even when you sent him a text message.
right. It was very difficult. And I could tell when he was testifying, he looked at me and said, I'm trying to save my law license. And I knew based on the timeline that the weekend before he had received a phone call from Mr. Wade to his best friend who had reminded him of his privilege. So at that point I knew, and you can almost tell my demeanor changed in my questioning at that point, because when he said that, I knew that he was worried about protecting his law license and he was not going to explain anything in detail. And so it was gonna be incumbent upon me to pull out those text messages and to remind him of everything that we had talked about.
Are you suggesting that?
Yeah, I think anyone would have done that in that very specific instance. Honestly, I think if you were on the stand, you'd have done the same thing. Absolutely. What's worth losing your career over? What is?
Whatever phone call may have been made by Nathan Wade through a best friend as intermediary to his former counsel was somehow witness tampering, or are you just saying that he was reminding him of an attorney-client relationship?
Well, we made those allegations in court that it wasn't, we didn't make the allegations that it was actually witness tampering, but he did call who was under subpoena and told him through a friend to pass along a message to remind him that he had privilege. And so I do think that that was something that that Mr. Bradley internalized, and that was the first time I had heard privilege. So prior to that, we had never heard the term privilege. In all of our conversations, and we've been talking for months, the term privilege had never come up. That had never been something where, you know, Mr. Bradley had said, oh, let me tell you this, but it's privilege. Nothing like that. So the first time that word even came up was when Mr. Wade interjected it into the conversation.
I wonder if there was more than one goal here. Because on the one
Yeah, but you're a lawyer, though, right? Like, you're both lawyers. You're fully aware of what is attorney and client privilege. You shouldn't have to wait for it to come out. You guys both know what is and what is not, right?
Wade interjected it into the conversation.
I wonder if there was more than one goal here. Because on the one hand, disqualification was certainly the goal. It was stated as such in your motion.
Right.
But it seemed as though another goal was to perhaps fatally undermine the credibility of this prosecution team, which...
Yes, that's it exclusively. There's almost nothing more than that. That's what makes sense here, bro.
Is to perhaps fatally undermine the credibility of this prosecution team,
That's
which
why the judge
frankly
threw it out.
is the right of defense counsel to zealously advocate for their clients. Do you think you were successful in trying to undermine the credibility of the prosecuting team?
Publicly.
Well, that was never a goal, and it's unfortunate.
Bro, stop playing. Publicly, absolutely. Like, because all that needed to happen was this conversation needed to become public. It enters into the public sphere, and then what happens? Everyone generally jumps to conclusions, right? This is why she was upset when she went and gave that speech where she was preaching. This is the same exact thing. There's no difference here. Fani Willis entered a lot of things into the public sphere. She then did the same exact thing by bringing up a disqualification hearing. The judge threw it out because it was pretty much obvious it was going to be thrown out. Had nothing to do with the actual case, right? And what's left here? You guys both did the same exact thing, and you're both angry at each other for doing the same exact thing, all right? Keep in mind, I am absolutely outside looking in here. All right. I don't know either of these people.
That their conduct is what led to that, but we did uncover a lot of conduct that I do think undermined their credibility, rightfully so. I think there's a lot of questions on their credibility. I think there's a lot of questions on misspending. There were a lot of things that we were not able to bring because it wasn't relevant. So there were a lot of questions that you would hear objected to, and I was not able to go into because of relevance, particularly the money issues. So we weren't able to establish all of that because we weren't permitted to go into that because of relevancy grounds. But I do think that now there's a lot of other entities that are investigating, and they'll be able to determine, hopefully, whether or not there was any misspending of public money, whether or not there were any other things that were going on that were illegal.
All right. And what does this have to do with the case that's being tried? Nothing. So the reason why the judge didn't allow you, because it was irrelevant. You even know that it's irrelevant based on the fact that you're saying relevancy issues. It doesn't mean anything to the actual case. This is why apparently she's not going to be removed. You're saying all of the answers, and you're confused why things are happening.
Spending of public money, whether or not there were any other things that were going on that were illegal.
Like, is she
of course,
right
that
for
was
the
what the
job?
judge pointed
No.
out in terms of the relevancy
Obviously.
and thinking about normally if there is an issue of credibility or otherwise, you take them down to the bar, the Georgia State bar I'm talking about, not the drinking kind, to deal with ethical issues of this nature. But on that point, you really didn't think that bringing up and having a motion to disqualify Nathan Wade and Fani Willis as the DA based on what you said was, a lack of candor and really intimating lying to the court, that would have an impact on their credibility?
Oh, no, I definitely knew that would have an impact. What I said was that's not my goal. So that wasn't my goal. And, it's one of those things as a defense lawyer, when you have information, you sit there and you think, if I do not use this, if I don't file this motion, no matter what harm it does to me, if I don't file that, am I going to one day be on the stand testifying at a post-conviction hearing, explaining why I had all this information and why I had case law to back it up and I didn't file that motion? And so that's what we're in a position. A lot of folks don't, who have never done what we do, who've never done defense work, may not understand that when we have this information, and Mr. Bradley called me and gave me all this information, I followed up on it and I tracked it all down. But once I had all that and I had the case law that supported my arguments, I had a duty to bring that motion.
Right.
So if I had not done that, I actually would have been deficient in my own performance.
And that's fair. It's absolutely fair, guys. Like, all of what you just said is completely accurate. It makes all the sense in the world. Do what you need to do, but just don't be surprised that it actually had no relevancy to what you were actually doing. I get it. It's information. You knew that it was going to be a media storm, I'm guessing. Again, this is the first time I'm hearing about Fani Willis. Never heard of her in my life, bro. Right? So just keep this in mind here. Of course, she had to do what she had to do in terms of her job, but it literally means nothing to what apparently Fani Willis is actually trying. It means nothing.
Well, the judge did not think you met the burden, but taking a big picture for a second. I mean, we all remember this moment when Fani Willis, the DA, held up the paperwork and the motions, actually requested the motions that she could hold up for you in court. You accused her of lying. She accused you of the same in open court. How do you respond to that?
I mean, at the time, I wasn't the one who was testifying. I very much wish I could have been testifying. And so that was difficult because, when you're an advocate and you're in court, you're asking the questions, you don't really get the opportunity to testify. And I had to wait until the judge ruled, out of fairness, until he ruled on the motion before I could actually address those issues. But it's very unfortunate when someone is calling you something and you know that it's not true and you can't really defend yourself.
That seemed to be her point too, right?
Right.
Right. Well, but she had the opportunity.
Because you're doing the same thing to each other. Literally. You're doing the same exact thing. Seems to be her point too. Yeah, bro.
That seemed to be her point too, right?
Right. Well, but she had the opportunity on the stand. She had the opportunity on the stand. She had the ability to bring other evidence. If she wanted, she could have brought other evidence. And I can tell you, if someone was accusing me of having an affair that I wasn't having, and I had evidence such as text records, such as phone records, such as credit card receipts, you better believe I would have brought that to court.
Well, that's interesting because, I might hold you to that when you talk about whether your own client will take the stand in his own defense, because one could argue if you don't have the burden of proof, you don't have to do anything to do so. But I'll move on for a second on that point because you mentioned the word relevance. And for so many people who were looking at this motion and this trial, they thought to themselves, okay, well, they were leaning in because it was intriguing to say the least. But none of it went to any of the facts alleged in the underlying indictment against the defendants in this case, against any of the defendants in this case, including former president, let alone your own client. And it was meant to simply be a way to stall or delay and not have this case be heard before the looming presidential election.
Yes.
Why do you not want the American people to hear a conclusion of this trial before that election?
Oh, I very much would like to go to trial. But the problem is, and I think the reason that a lot of the public didn't really understand what was behind this or, the reasons for filing this is because they may not understand due process in our Constitution. We have a right to have a fair and impartial.
She just insulted you guys.
Prosecutor evaluate the case. And that didn't happen in this case.
I saw that in the Washington Post, they reported that the former President Donald Trump liked your motion so much that they had an aide ask his lawyer, Steve Sadow, to call you and congratulate you. Is that true? And what was your reaction to that call?
My reaction to that article was very surprised. I was surprised, and I don't know who talked about that. I did not I didn't have any help. So, I think it's important to look back at how this began. This was me. This was not an effort by anyone else. I filed this alone. And if you look back at the timeline, I filed this on the deadline that my motions were due. Nobody joined my motion for well over a week. And you even see Donald Trump's lawyer in court a few days later saying he had to evaluate whether or not he was even going to join it. So I think that is clear evidence that this was not an effort. This was not an effort by anyone else. And so I know that everybody likes to sort of lump all of the defendants together and say, oh, well, this was, Donald Trump's motion, or this is his lawyer or something like that. I represent Michael Roman. That is who I represent. That is my duty. And I was the only one that filed this motion. Mm-hmm. I had help once they all joined, and I was very pleased to have the team, surround me and embrace the motion and embrace all of the evidence that I had developed. But I want to be clear that this was not a motion filed by anybody else. This was something that I had developed on my own.
Meanwhile, tonight there is now a oversight panel with the power to discipline and even remove state prosecutors.
Governor Brian Kemp signed that bill into law today, saying that the panel will hold prosecuting attorneys accountable for their actions.
And with the stroke of a pen, it was official. Governor Brian Kemp says the state will hold district attorneys accountable.
Today we are renewing our commitment that we won't forfeit public safety for prosecutors who let criminals off the hook.
The new law revives the Prosecuting Attorney Qualification Commission, tasked with overseeing complaints filed against district attorneys and solicitor generals. The commission can investigate alleged misconduct, discipline, remove, or even force retirement, depending on the situation.
When out-of-touch prosecutors put politics over public safety, the community suffers and people and property are put at risk.
Previous versions of the law restrict the disciplining of a DA until the Supreme Court affirmed the ruling. But in November, the state Supreme Court refused to approve the rule. The version signed today removes that requirement and gives the 8-person panel more power to move forward without the Supreme Court.
Guys, this definitely seems like an interesting thing to follow. And again, so this is my first time actually hearing this person's name, finding out kind of what's going on. Does it feel like it's a stalling tactic? It does. It absolutely does. It feels like they're stalling because they don't want some type of response to be seen before some type of election. Is it plausible? We're talking about the United States of America. Who's going to run the United States of America? It's absolutely a plausible thing, guys. Now, if she herself, should she be in the position that she's in, if she's using her power to hire people that are extremely, that she's near and dear to, right? That have no real knowledge of the job, basically? Yeah, that's somewhat troubling, bro, right? That instance, on that very specific instance, yeah, that's crazy. It's wild. But does that have any relevancy to whatever case that she's attempting to try currently? No, has no relevancy at all. Hence the reason why the judge declined it. It's pretty obvious logically, I think, right? Remove all emotion from the situation here. It has nothing to do with anything. But she also shouldn't remain in this job based off of what she has done. That's where I'm at. But all right, listen, you guys all have an absolutely amazing day. Enjoy your day thoroughly. Guys, before we go, are you guys subscribed to the other channels? Logical Movie Reviews with Mr. L. Boyd, along with Mr. L. Boyd Music. Both are found in the description. Check it out.